Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.
We hope you enjoy listening to this podcast of St. Louis on the Air, brought to you by University College at Washington University. With undergraduate and graduate programs, part-time, evening, and online. University College at Washington University, offering world-class education within reach.
Welcome to St. Louis on the Air. I'm Don Marsh. Lawyers and legal issues are getting a pretty good workout these days, both in Washington and in our own backyard. Lots going on. And that's why we convene our Legal Roundtable every month to try and get a better understanding of what's happening and why. Joining me in studio are attorneys Bill Freivogel. He teaches journalism at SIU in Carbondale. Mark Smith is the Associate Vice Chancellor and Dean for Career Services at Washington University. Also from WashU and his School of Law is Rachel Sachs, back with us once again. Thank you all for being with us. Great to have you.
Thank you.
Hi.
Thank you.
Where do we start with regard to the Washington story? Let me just read some of the things that have been going on in the very recent past. We have the Barr hearings, the Attorney General designate. What are we learning about him? Michael Cohen and that BuzzFeed story that he was ordered to lie by the president. The Mueller dismissal of that BuzzFeed story. The shutdown standoff. The Supreme Court upholds restrictions on transgender people in the military. Supreme Court will not review the Trump decision to end DACA. And we'll take up a gun rights case next term. First time in a decade it's done that. And it's also the fact that Donald Trump has asked for the Supreme Court to, in speedy fashion, make a decision on that citizenship question that he wants on the census. Where do we start, Bill? What are your thoughts? What stands out to you?
Why don't we start with the Mueller probe and all of the stories surrounding that. So we had the confirmation hearing for William Barr to be Attorney General. The biggest issue sort of growing out of that is, how satisfactory was his promise to release information from a Mueller report. Basically, Barr said he would release what he could release consistent with the law, and that his general feeling was release as much information as possible and let the chips fall where they may. Some of the Democrats on the committee, I think Dianne Feinstein, for example, on the Senate Judiciary Committee, felt as though that was not a full enough promise to release everything that could be released. I noticed that the Washington Post, which has certainly been leading, doing lots of the reporting on the scandal, editorially said they thought that Barr's promise was sufficient and about as far as he could go. I think Barr will be confirmed, probably the best attorney general candidate that maybe Democrats or liberals or the country could expect to come from this White House. At least that would be my opinion. Meanwhile, then we have this BuzzFeed story, which Mueller took the unusual step of basically denying. BuzzFeed said that Trump had ordered Cohen to lie to Congress about how long the negotiations were going on between Trump and Russia over a Trump Tower in Moscow. The BuzzFeed story had quite a bit of detail about what Mueller's office had in terms of documentation and emails. And at the end of the day, the Mueller office issued basically a denial saying that the story was wrong.
At least a part of the story.
At least a part of the story. Yeah. Well, so BuzzFeed comes back and says, "Well, tell us what part's wrong."
Yeah. And they're standing by the story.
And they're standing by the story. Yeah. It doesn't. And of course, then President Trump and a number of Republicans were able to say, "See, fake news. Exactly what we've been telling you about the media." It's you sure don't like to be a reporter who has an exclusive that nobody else can get. Mm-hmm. And that's where BuzzFeed is. And, my gut feeling is that there's some important details of that story that are wrong. But it's important for people to remember, that what we do know is that Cohen, the president's lawyer, has pled guilty to lying to Congress about how long the negotiations were going on. Trump had said, we don't got any dealings going. We don't have any dealings going on with Russia. Earlier, it had been said it was all over by the beginning of 2016. Then it turns out that it is confirmed by Cohen that those talks to build a Trump Tower were at least going on until June of 2016. So after Trump was the Republican nominee for president. Then we have Rudy Giuliani coming in and making an even greater mess out of it by saying, those talks were actually going on as late as the election. The president told me they were going on as late as the election. Then he comes out the next day and says, "Oh no, that wasn't what I meant to be saying. I was saying in the hypothetical." That they were going on until the election. There wouldn't be anything illegal about that. My gut, there's been a lot of criticism of Giuliani sort of seeming like a clown. But, I think to a certain extent he was trying to get out an unfavorable fact at a time when BuzzFeed had made the critics of the president look bad. And so I think that Giuliani's overall strategy is to get out the unfavorable facts so that when Mueller reports them, they won't seem like news, and to do it in as confusing a way as possible to confuse the American people. That's my own
And
feeling.
he's certainly succeeding in that.
Yes.
What kind of ratings do you all think that Mr. Cohen is going to get in February when he testifies before Congress? Probably be bigger
Pretty
than
big,
the Super Bowl.
And then you also had Trump going after, I guess he called into one of the shows on Fox to say they ought to be looking at Cohen's father-in-law. That's where the real story is. And then
Didn't he tweet about it as well?
Oh, yeah, I think so. But all these criminal defense lawyers saying, it was interesting. I was reading some said, if I had a client who did that, I would get rid of him. That's, you can't do that. But then there was also at least one who said, but with Trump, because he says all these outrageous things and you have to have a specific intent, this could just be, he just talks like this all the time. It's no big deal, and that he might be able to get out from the argument that he's trying to keep a witness from testifying. Another thing that we were talking about before the show, there's been before the Supreme Court, there's apparently Mueller has subpoenaed either, I'm not completely clear. It seems like it's a corporation and a country, and maybe the corporation is completely owned by the country.
That's right.
Country A, which I assume is Russia, but and the country is fighting the subpoena for certain records. And right now, I think what's going on is the Supreme Court has lifted the stay. It's still being appealed, but this country is being fined, I think it's $50,000 a day for every day they don't respond to this subpoena for information.
We've got Country A and Individual One. This is getting...
whole floors of the federal courthouse in Washington, D.C. have been cleared of all reporters and individuals so that this case that Mark is talking about could play out in secret, and we couldn't be able to figure out who Country. Yeah, we don't even know who the lawyers are.
The lawyers is redacted. You never see that.
Country A, yeah. Really unusual situation.
The Supreme Court gave a little bit of a hit to Trump yesterday with regard, I guess it was yesterday, with regard to DACA, which these kids who came over with their parents illegally have another year or so before the court will take up that case. So that has been put on the back burner for a while. Apparently.
Yeah, in a number of cases, the Trump administration has been asking the Supreme Court to speed up things and jump over the courts of appeals and all, and they don't seem to be particularly inclined to do that in the DACA case. So that basically means that because the Trump order to get rid of Obama's DACA order that helps the Dreamers, because the courts have put the Trump rescinding of that on, they have stopped its enforcement. That means that because the court's not going to hurry up any kind of hearings on that issue, we're into like 2020 with the Obama rule in place. And so as a result, this compromise about opening up the government that Trump had, which was So for some of these dreamers, I'll let this Obama DACA era thing go forward as part of the compromise. Well, it's going to anyway, so he's not giving up anything, and what he was giving up in the first place was what he had taken away.
Yeah.
Rachel, the Trump administration has also asked the Supreme Court to accelerate action on the citizenship question for the census. I know you have some interest in that. What is your issue with that?
Well, my interest is primarily in the Administrative Procedure Act. So as a law professor, this is the statute that governs a lot of how administrative agencies make decisions, change policies, make rules. And there was this question about whether the government could add a citizenship question to the 2020 census, which by most estimates would have really changed who is responding to the survey. And so the district court struck it down under the Administrative Procedure Act quite clearly. And I just want to flag for our listeners, there was a very interesting article out in the New York Times yesterday showing that 30 big regulations from the Trump administration have been challenged, and they've lost 28 times on Administrative Procedure Act grounds. This administration has a habit of moving out major policy decisions without supporting them with the kinds of evidence we've seen from previous administrations. So it's really not a surprise that they lost here in the district court on these grounds, especially given their rates in all of these other cases. But as you were mentioning a moment ago, the Solicitor General's office really is trying to leapfrog the courts of appeals and take a lot of these issues to the Supreme Court much more quickly. And it's possible that the Supreme Court is getting a little tired of it, or it's possible that they might take a couple of these cases, but there's so many that they've asked them to take so quickly.
Of course, members of the immigrant community, if you will, Hispanic population, very much concerned that if this question is on the census form and if it's answered accurately, it costs them their chance to stay in this country.
Right, that it would decrease people filling out the census. It's interesting on this case, exactly as Rachel said, this was struck down by the district court judge based on a violation of the Administrative Procedure Act, which says before you can make certain changes, you have to do notice and comment, and you got to jump through some hoops. It was not based on a finding of discrimination or discriminatory intent. And part of that is because they couldn't depose, Secretary of Commerce?
Wilbur Ross.
Yes, Ross, right. And so they said they could not meet the evidentiary standard to prove that because they couldn't do the deposition. So it stopped, but I think it may. Well, I guess it just stopped, and they'll probably not do the other stuff because they'll have to go on with the census.
Well, in some cases, administrative agencies are trying to go through the required process after one of these losses in court, but if after going through the process and receiving a lot of negative comments about what it is that you're proposing to do, if you come out with exactly the same policy, the courts might look a little bit more critically at that. Now, if you change it somewhat, then they'll likely to look more favorably, and I expect them to win on at least some of these issues in the long run, but it's taking them a lot longer because they have really tried to circumvent the process.
A couple reasons it's important if a bunch of Hispanic Americans decide not to answer the census is that would determine how much money goes to separate parts of the country and also determines how congressional seats are apportioned around the country.
We got to take a break now. We'll come back and talk about another discrimination issue. You used that word a moment ago, Mark, a little closer to home. We'll do that. This is the Legal Roundtable panel, and we'll continue our discussion in just a moment. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU. Now back to our Legal Roundtable panel of Rachel Sachs, Bill Freivogel, and Mark Smith. Okay, here is a pretty interesting and big story, I think, for the local community. A federal judge has dismissed a discrimination suit filed by a married St. Louis lesbian couple who were denied admission to a local retirement center. Mary Walsh and Beverly Nance took Friendship Village to federal court for sex discrimination. Judge Jean Hamilton ruled Fair Housing Act prohibits discrimination on the basis of sex, but sexual orientation was not mentioned. Why was it parsed that way? Mark, do you know?
Yeah. Well, I read her decision, and what she says is, first the complaint was under the Missouri Human Rights Act and the Fair Housing, and then just under the Fair Housing. But under both statutes, one federal, one state, sexual orientation is not a protected class. And Judge Hamilton says this is not sex discrimination, and basically says for two reasons. Basically, the main reason is because the Eighth Circuit has said sexual orientation doesn't come here. And she says they wouldn't have treated two men trying to live together differently than two women. So, but she does acknowledge a lot of other federal courts of appeals have found this to be discrimination, but that Judge Hamilton, as a district court judge in the Eighth Circuit, is bound until the Eighth Circuit changes, she can't change.
Rachel, how can it not be discrimination when the Supreme Court has ruled on the legality of same-sex marriage?
Well, the statute says sex. It doesn't say sexual orientation. And there's another context in which the courts are addressing this as well, which is employment discrimination under Title VII of the Civil Rights Act. And at least two courts of appeals, the Seventh Circuit, which is based sort of in Chicago, and the Second Circuit, which is based in New York, they have held that even though Title VII also only says sex, it covers sexual orientation discrimination. And the idea is that discrimination on the basis of someone's sexual orientation is motivated by their sex. It's motivated by their nonconformity with this gender role that we've envisioned for them. And so at least these two circuits allow you to pursue claims for sexual orientation discrimination, even though the statutes were passed decades ago and they just say sex. So it's possible that the Eighth Circuit, might be re-entering this issue as well.
They've been trying to get the sexual orientation phrase into the Missouri Human Rights Act for 20 years.
Right, and there's been long efforts to explicitly get the federal civil rights law also to include protections for transgender and for gays and lesbian as well. I answer your question partly. Everything Rachel says is correct, and then in addition, the difference between this and gay marriage is that was a constitutional decision. So the Supreme Court said the Constitution, equal protection, liberty protected by due process of law. For all those, because of the equal dignity that gives every American, you can't pass laws against same-sex marriage. This is a statute. These are the civil rights statutes. So it's a completely different sort of body of law. And what do they cover? They cover the things that they mention. They say sex. They don't say sexual orientation. So the question is, should sex include sexual orientation? The Eighth Circuit's not it's probably the most conservative court of appeals in the country. And so whether or not they'll reconsider, we'll see.
But when you read the decision, and I don't know if it was in the plaintiff's brief or in Judge Hamilton's decision, but these women, they've spent their whole working life hiding their sexual orientation because they were worried they would get fired because if their relationship was known or if their orientation was known, because while the law says you can't fire someone because of their race, the law doesn't protect someone on orientation. And they said, okay, so now we're retired, we can come out, we can live our lives the way we want to, and now they can't get into this retirement home. And it's really sad.
The lawyer for the two ladies was with us yesterday and announced the obvious, and that she's going to be appealing this decision, but I don't think that caught anybody by surprise. Yeah.
I mean, even though I totally disagree with Judge Hamilton's decision, she's the one who said that the sex did not include sexual orientation. She was just following what the Court of Appeals says. So she was doing what a district judge is supposed to do.
Moving on to another subject, unless someone has something they'd like to add, let's go to the potential for a statewide vote on a merger, union, consolidation, or whatever you want to call it, between St. Louis City and St. Louis County. If we go to a statewide vote, and it passes in the state but fails in the city of St. Louis and St. Louis County, what then? I mean, this seems to me to be kind of a legal dilemma. Any thoughts?
Well, I think the statewide vote would apply, and people here would be upset. I mean, it's it's really interesting. We've been fighting about this for as long as I've been alive, and it's also interesting that you've got.
That's a long time.
That's a long time, right? And it's also interesting. You got Rex Sinquefield, who's sort of like the major Republican donor in the state of Missouri, funding this drive. But then you have a lot of progressives and liberals who like to see, us get rid of all those little tiny St. Louis County police departments that aren't many of whom are not very professional, on that side of merger also. So you have an interesting combination of conservatives and liberals pushing this. Then on the other hand, you just have local elected officials who say, you can't take away, you shouldn't be able to take away our police department.
It also seems to be a weird kind of compromise. Police departments, local police departments would be eliminated, taxing.
Some.
But not fire departments and not schools. So we've picked some, but not others.
Well, schools would be a third rail. There's no,
Well, I think, they're. But.
We'll find out before the end of the month what Better Together, the organization putting this together, actually is going to come up with, what the plan is. But there seems to be some public knowledge of what they have in mind. And Lyda Cruson and Steve Stenger are okay with a statewide vote, so there we go.
And Sinquefield's got a lot of money, and so he seems to care deeply about this. So
he seems to care deeply about the city earnings tax, and that's what a lot of people, including our Joe Manis, is very, very emphatic about. That's what he's really, really getting at. He wants to see that eliminated.
And, the other group that we sort of left out of this discussion is, I think some of the African-American Democrats are not very happy with this proposal. First of all, I think they would think it would decrease the power of African-American Democrats. And dilute it. And, the whole city court system would go away.
Right.
As I understand it.
No, that's my understanding, too. One court system.
Yeah. Okay, well, we're going to have the Better Together people on when this is announced. I think it's going to be announced next week because it's going to be happening before the end of the month, though. We'll look forward to that. I think we've got them scheduled for next Tuesday, as a matter of fact. So that gives us a hint as to when the report's actually going to be released. Okay, here's one that Bill and Mark, because he has been on the program sitting in Rachel's seat so often, Mike Wolf is now joining Wesley Bell's office. I thought that was very interesting as a coup, I think, for Wesley Bell to get someone of that stature to be working with him. What do you know about that, Bill? What's he going to be doing?
Oh, I was talking to Mike a little bit about this last week, and I think he was the head of the transition committee and has been advising Wesley Bell. I think he's a terrific choice. I don't know anybody who knows more about what's the way things work in Missouri and in the court system than Mike, as former Chief Justice of the Missouri Supreme Court, former Dean at St. Louis University Law School, and a former reporter, which always is a really important credential to have. So I think it's a terrific decision on Wesley Bell's part. I think I'm hopeful that for that and many other reasons that he will have more success than maybe Kim Gardner has had so far.
And besides knowing how things work, he also knows everybody. I mean, in the legal community, I can't really think of anyone who is more well known, because he's been active in politics. He's been, as a Supreme Court judge, as the dean. He met, all the St. Louis U law alums. I mean, he is very well known and could, I think, intervene with different people to say, hey, we need your help here, or we want you to do this. And I think he's got a lot of gravitas that could maybe make that happen for a
Bill is also picking up Robert Steele, who was a prosecutor in Kim Bell's office, and I guess most recently best known for having lost the Stockley verdict.
Right.
Yeah.
So, but I don't know that he is blamed for that. And I want to make clear that I don't want to just portray this as the great white savior, Mike Wolf, coming in to save Wesley Bell. I think Wesley Bell has done extraordinarily good, amazing work to get elected in the first place, and is taking pretty careful steps as he gets going.
Sounds like Steele was like kind of a mentor to Bell, and so this
absolutely.
is
And he's had 30 plus years of experience, so that's certainly helpful too. Anyway, okay, Rachel, I know this is something you wanted to talk about, and that's the Affordable Care Act, Obamacare court ruling in Texas. A judge declared the Affordable Care Act unconstitutional. Says it can remain in place while legal challenges play out. But what are your thoughts about where this is right now? And is there any question in your mind that this is not going to the Supreme Court?
Right. So as a law professor, as someone who knows that people are confused about this, because it's confusing, I did want to talk about this. So remember that this is the lawsuit brought by a number of Republican state attorneys general, including at the time Josh Hawley, who's now a senator. And the suit, they're seeking to declare the entire Affordable Care Act unconstitutional. And so if they win, that means that not just the 20 million or so Americans who now have access to coverage through the act would lose it, but there's so much more in the act, and almost everyone's access to healthcare would be affected. So the ACA made it easier for Medicare beneficiaries to afford prescription drugs that close the Medicare donut hole. That would go away if the law were invalidated. You know, the ACA's protections for pre-existing conditions would go away if the law were invalidated. And so we're jeopardizing all different kinds of benefits. And so, as you said, the most important thing is that the law does remain in force for now, but I think we will continue to see the case be litigated throughout the system. It's possible that it doesn't get to the Supreme Court. There are a number of routes by which the Fifth Circuit Court of Appeals could decide that the parties lack the legal standing to bring the lawsuit, and then the Supreme Court maybe chooses not to take it up during a presidential election year. That is a possibility. I think it's too early to say. But as we've seen with many lawsuits over the Affordable Care Act, nothing is certain, even though on this one, we do have lawyers who've been on opposite sides of previous cases involving the act pretty much agreeing and saying that this lawsuit sweeps much too broadly. Even the Trump administration won't go as far as the plaintiffs have here. So the Trump administration would like to see just a couple of provisions of the act struck down, including the Trump administration would like to strike down the pre-existing conditions protections, but they're happy to keep the Medicaid expansion, they're happy to keep the Medicare protections and things like that. So it's very possible that that is the position that ends up being seen as more plausible by the appellate court.
And the way we got here was we had a Supreme Court case, like 4 or 5 years ago, where the Supreme Court was considering the constitutionality of the ACA, and 4 of the conservative justices said there were 3 possible justifications for the law that the feds could pass it. One was Commerce Clause, which had always been this really broad power, and Congress could basically do anything under it. Taxing power, and the Necessary and Proper Clause. And the 4 conservatives said and Roberts said Commerce Clause does not go broad enough to this, which kind of shocked everyone because, like, when I was in law school, Commerce Clause did everything, but Roberts said, but taxing does. And then we had the tax changes, the Trump tax changes, where they lowered the penalty tax to 0. Didn't do away with it, but it's at 0. So the argument is, well, now there's no authority under the taxing power. You got 5 that say. So then the next issue is it severable? Do we just get rid of that part of the law, the mandate, or do we get rid of all these others? And the 2 big ones are the one that says you have to set rates the same for people. The only thing you can look at is age. So if you have diabetes, your rate would typically be 4 times more, but under this you can't. And then the pre-existing conditions. So even if they don't eliminate the whole law, if this just stands where people don't have to come in, I think what you're going to see is healthy people starting to clear out, which is going to raise the rates and make this law much just less practical working. Plus, you've got the changes from Trump where these people are able to create their own little health care plans that don't comply. So you're getting these kind of bad healthcare plans that don't cover all these conditions. So all these things are kind of coming together at one time.
And this year was the first year without, or
This
year
year
for
will be, right,
Affordable
yeah.
Care Act sign-ups. So this
Yeah.
fall was the first time for sign-ups for the individual market under the Act without the individual mandate penalty really being significantly enforced. And sign-ups fell, but only by about
Slightly,
4%. So it was a very small number. And at the same time, we also saw some states expanding Medicaid. So I think the numbers are still unclear. But what is clear is that the market didn't immediately collapse.
Right.
As many had predicted at the time. And so it might be that the mandate was really necessary at the beginning to establish the market, to get people into the market, have them know that these options are available to them. But now that people have had coverage for several years, it is possibly a little bit less necessary to keep them in the market, especially because for many Americans, these plans are so heavily subsidized. Many Americans can get free plans or low-cost plans under the Affordable Care Act.
Getting ready to take a break, and I'll do that. And we have a call. Jerry wants to talk about the Affordable Care Act, but we'll wait until after the break before we bring him in. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU. Welcome back as we continue our Legal Roundtable panel discussion with Bill Freivogel, Rachel Sachs, and Mark Smith. As promised, Jerry in O'Fallon has been waiting to talk about the Affordable Care Act. Jerry, go ahead, please, but make it quick. Time's a-wasting.
Good afternoon. This is one of the best hours for information. Anyway, as I understand it, the ruling on from the Texas judge has to do with identifying the penalty as a tax and then stating that Americans cannot be or should not be forced to pay a tax on something they do not want. And if that, in fact, stands up to a challenge, wouldn't that open just a huge category of things that Americans could withhold their tax money, saying that they really don't want it?
All right, let's find out. Rachel, I'm going to throw that at you.
Well, I'm not a constitutional or expert, but there are a number of cases about people objecting to the use of taxpayer dollars for particular purposes, and you can't object to that. The courts have said that it's extremely difficult to establish opposition to that. What's happening here is they're trying to say, I'm being made to pay an individual penalty for this specific purpose. And of course, one response to that is actually you're not being made to pay any money because the tax is now $0. So you, in theory, don't have the legal standing to bring this case. So normally, although the caller is right, and we think about pocketbook injuries giving you a classic case for standing, you typically aren't able to just say taxpayer dollars are being spent on this particular item that is objectionable to me for whatever reason, therefore I don't want to pay it.
And here you have both individual taxpayers and the attorneys general from these different states. So there's a huge standing issue that the judge kind of glossed over, and so a lot of people are saying we may be able to get rid of this case based on standing, which is standing is this legal concept that not everyone can just bring a lawsuit. You have to have skin in the game, basically.
You have to be harmed by whatever it is that has happened to you.
A couple of other things I'd like to get to, but let's bring in some listeners who want to be part of the conversation first. And we'll start with Fred, calling from Glendale. Fred, welcome. You're on the air.
Hello?
Go ahead, Fred.
Yeah, Don, I was interested in the Friendly Village case.
Friendship Village.
Yeah.
Yeah, go ahead.
Yeah, okay. It's also a housing unit, but it's also a commercial enterprise. And I was wondering if the Hobby Lobby decision would have any influence on this particular case in question.
Fred, thank you for the call. Anybody have any thoughts on that?
I think it might, but I don't. But given that Missouri law and the federal housing law doesn't get to sexual orientation, you don't need to get to the Hobby Lobby yet. Now, I don't know enough about this Friendship Village. I assume they're some kind of religious organization, but I don't know that for a fact. But the main reason is, like we were saying before, this is based on statute, and the statute says you can't discriminate on sex, but it doesn't say anything about discriminating on sexual orientation. So, people discriminate in hiring. If you want to not hire me because I'm over 6'4", you can do that. That's allowed, but you can't discriminate because I'm a man, because I'm in a protected class.
Remind us about Hobby Lobby. How does that relate?
Hobby Lobby has to do with, and I didn't prepare on that one, but you probably know more about this, but it was where your religious beliefs, you're forced to kind of do something contrary to your religious beliefs. So that would cover this. It's kind of a forced speech type of
Hobby Lobby is a case, again, an Affordable Care Act case.
Right.
The ACA required employers to provide certain contraceptives to their female or to their employees more generally. And they, at the same time, had exceptions for certain religious organizations. And so this lawsuit was really about the question of whether those existing exemptions sort of undermined the purpose of the the purpose of the regulation enough that they should be extended to these closely held for-profit companies. And so there's a lot of different aspects of the Hobby Lobby case that are relevant to this kind of question. As Mark was saying, assuming that we were to extend sexual orientation discrimination protections here, but at the same time, there already were these exceptions for other kinds of organizations. The Fair Housing Act does have certain kinds of exceptions, but they're much narrower than would need to be the case for this large entity to meet them.
Fred, it's a good question because in each case, we're talking about a company or a small enterprise that has a religious belief and whether or not they can follow that religious belief. Hobby Lobby, had certain religious beliefs, a closely held corporation, certain religious beliefs on contraception. Friendship Village has certain religious beliefs on what constitutes marriage. But we're talking about two separate laws. The Hobby Lobby case was an interpretation of the Religious Freedom Restoration Act. Here, in the Friendship Village case, we're talking about Title VIII of the Fair Housing Act, civil rights law. So we're talking about two separate laws, and so the issue then becomes different in each case.
And also we have the Masterpiece Cake, because that was a state anti-discrimination statute, but the First Amendment there. So, and it was more about forced speech. So this is a area of the law that very much in flux, I think.
And there are questions here about whether corporations, or not whether, but under what circumstances corporations can really have
versus an individual,
religious beliefs, right? So when we say Hobby Lobby has this belief, well, it's Hobby Lobby, it's the individuals who are the owners of Hobby Lobby. But, in principle, once you open that box, there's a lot of concern that there's no reason why you couldn't extend it much more broadly than that.
Hobby Lobby is a fiction created by the state of Oklahoma or Delaware.
Fiction.
Legal
fiction,
right.
Yeah.
Let's take one more call, then we'll move on. Eric in St. Louis, go ahead quickly, please.
Hi, I was interested in the comment that was made about Kim Gardner being less successful than Wesley Bell, and I'd be interested in your assessment of Kim Gardner's performance, especially I'm interested in the question of her position on smoking marijuana in light of both New Yorker and New York Times articles that question the wisdom of proceeding so quickly to legalize marijuana when so little is known scientifically about the effects of marijuana, although we do know secondhand smoke is highly carcinogenic.
Eric, thanks for the call. Bill, I think he's referring to something you said.
I'm afraid I'm the one who said that. I mean, I had high hopes for Kim Gardner. I still have high hopes for Kim Gardner, but she's had a very rough time so far. Lots of lawyers leaving, veteran prosecutors leaving the office. Her handling of the case involving the former governor, the Greitens, was not exemplary. I think some people think probably she shouldn't have brought the case if she didn't have the photo, so I think she's had a rough first couple of years of her term. I hope she can turn that around. I too sort of have my reservations about moving headlong into all this legalization of marijuana, but I don't know all the details about Kim Gardner in relation to that.
And you call yourself a child of the 60s. I can't believe that.
All right, let's move on to another subject now. Governor Parson wants to repeal Amendment 1, the Clean Missouri Act, establishes a new nonpartisan method of creating legislative districts, gerrymandering, in other words. But the voters, just a couple of months ago, decided that that's something, in fact, that they wanted. Can he overturn it? How does that work?
Well, he'd have to go back and get he'd have to get the legislature, I think, to send it back to the voters. What amazes me about this is that the way in which the Republicans in this state are able, without seeming political consequences, to continually go against the views of the majority of voters in referenda. I mean, we're talking about this is about the fifth issue. The concealed carry, minimum wage, puppy mills, right to work. Now campaign finance reform, and I think there's actually a previous campaign contribution limit issue. So, I mean, the legislature has ignored what the majority of people in Missouri say on all those things, and or threatens to. And how did they get by with this and still have a veto proof for a very high majority of Republicans in the legislature? So it's a mystery to me.
And it passed 62-38. It wasn't close.
Right.
So, I do think it's unfortunate that the governor and many legislators are not respecting the clearly chosen will of the people on this question. Now, because it is a constitutional amendment, they can't simply pass a law and get rid of all of it, although there are things it sounds like they can do to the Sunshine Act, which is closely related to some of the amendment's provisions, or other statutes that might limit Amendment 1's impact on certain legislators. So it's possible that we might see some of that, especially in the near term. But also, this is of a piece with what we've seen in other states when laws are passed or elections are held, which undermine the power of sitting lawmakers. Increasingly, they are responding by trying to undermine those laws, making it harder to do ballot initiatives in the future. And these are dangerous developments, and people should be very concerned.
So I agree with everything was said, but I would say two things. One, I don't know that voter initiatives are always the smartest way to change the law or change the Constitution.
Yes.
And we saw that with the marijuana thing, where we had three, you had to pick A, B, or C, which one you wanted. So that's one thing. The second thing is, I think this redistricting, we had Brenda Talent on a few years, and she raised some concerns about how hard the redistricting is. And we're seeing this with some Supreme Court cases, and it looks like the Supreme Court may consider this partisan gerrymandering issue again. And I was talking to a math PhD at WashU who's done some work on this, and she said, part of the issue, some of it's Republicans and Democrats playing fast and loose, but some of it is just we have chosen to live with people of the same party. In many ways, we've packed ourselves into these 70% districts just by normal by the way we've chosen to live, and that makes it much more difficult to, even when the state might be close to 50-50, to have 50-50 in terms of districts. So I think it's harder than it looks.
Mark mentioned the Supreme Court has agreed this year to look at the Maryland and North Carolina partisan gerrymandering cases. My gut feeling is that they're looking at it, but not to say that there's that they're going to throw anything out for being a partisan gerrymander. I don't think they have. They needed Justice Kennedy to have that.
Kennedy was the one that was kind of wavering, right?
Yeah, I would doubt that that there's 5 votes to throw anything out anymore as a partisan gerrymander.
They're talking about the two cases from the two states, North Carolina and Maryland. What are the differences there?
Well, the difference is the North Carolina one is a Republican gerrymander, and the Maryland one is a Democratic gerrymander. North Carolina in statewide votes is pretty close, Republican versus Democrat, but 10 of 13 members of Congress are Republican because of the way the districts are drawn. In Maryland, which is pretty much of a Democratic state, 7 of 8 districts are Democrat, and they very specifically designed a particular district that's at issue in the case to flip from a Republican incumbent to a Democrat. So pretty clearly it was partisan gerrymandering, but I don't think the Supreme Court's going to see that's unconstitutional.
Another local issue I'd like to get to is the fact that it seems like the Missouri Supreme Court is going to get into these debate, and sometimes heated debate, over the public defenders in Missouri and whether or not, in fact, they are overworked, and that, in fact, that presents a constitutional problem because defendants aren't getting the kind of defense that they're used to. We've gone down this road before, Bill, not with the Supreme Court, Missouri Supreme Court, but
actually, even with the Missouri Supreme Court had a decision back in, I think it was 2012 or something, on this public defender issue. But Missouri has got they pay like $350 per defendant in public defender cases. That's the lowest in the country, except for Mississippi. It'll be interesting. I mean, what you refer to is the Court of Appeals said they were transferring an appeal. The Missouri Court of Appeals said they were transferring an appeal to the Missouri Supreme Court on the question of when could public defenders say they can't take a case because they can't give adequate defense to their client. And so I think it's good to have them involved again.
Yeah. Maybe we'll get something definitive.
And just to remind your listeners, I mean, they might say, well, $350, I don't want to pay to defend criminals, but this is a constitutional right. The Constitution says we have to do this as a government, and so we can't not do this. We have to. But it's very hard then, because they're holding these public defenders responsible if they don't put enough time in to do the job correctly.
It'll be interesting how the disappearance of Bob McCullough will affect this, because McCullough's been the main voice challenging the public defender's claims of inadequate resources.
He's talked about it on this program.
He's
passionate about it.
He's the person who is the other side. In this case, it's been transferred to the Missouri Supreme Court. So, I mean, Leslie Bell's not going to take the position that McCullough did, I wouldn't think.
I'd like to talk about a couple of jurists just in the time that we have remaining. The first African-American woman to serve as presiding judge in St. Louis has gotten a promotion. Circuit Judge Robin Ransom has been appointed to the Missouri Court of Appeals for the Eastern District. It's almost hard to believe that it's taken this long to get an African-American on the Court of Appeals.
No, we've had African-Americans on the court. She's the first
But
woman.
St. Louis judge. Okay,
presiding.
I'm misreading that.
Presiding.
Okay,
because
so that's
we've had,
my error.
I think McMillan was on the Missouri
Theodore
Court of
McMillan.
Appeals before he got on the Eighth Circuit, wasn't he? I'm not sure. But we've had others. Booker Shaw, who's been on the show with us, he was on the Missouri Court of Appeals.
Okay, well, that's my
But
mistake.
she's the first African-American woman, I think.
I looked up her. I don't know much about her. I looked up the evaluation that there always is of judges, and how did lawyers evaluate her as a judge? And she got really good ratings from the lawyers who had appeared before her for being, prepared, interested, listening, making sense of, giving good reasons for her decisions. So I thought that was
we'll wish her well, and I'm sure we're all wishing well Ruth Bader Ginsburg as well. This is we only have a little more than a minute left, but she is, as we all know, she had some cancerous nodules removed from her lungs. She's been missing some sessions, but she's still been participating from home. This is something that a lot of people, particularly on the liberal, progressive side of the scale, are watching very closely.
Yeah, if she were to have to leave the court or leave the court, President Trump would have another appointment, and we'd be talking about a 6-3 instead of a 5-4 split between Republican-appointed judges and Democratic-appointed judge. And as we all know from the movies, the current movie, I mean, she is an icon
right.
Whose sort of fame has only grown as she's gotten older.
I took my 17-year-old daughter to see the movie Friday night, and Laura Smith just loved. Ginsburg was a hero for her before, but even more so after seeing the movie and kind of understanding what she was, coming out of Harvard Law School or Columbia and struggling. Yeah.
And she deserves it. She's the Thurgood Marshall of the women's rights movement.
Exactly.
Do you want to say something nice about Ruth Bader Ginsburg in 10 seconds?
We didn't let the woman at the table say
Yeah,
anything.
right. Yeah, sorry.
We don't have that kind of time. I think we are all wishing her a speedy recovery.
All right. Well, Rachel Sachs, thank you so much for being with us. Nice to see you again. Come back and join us again sometime. Mark Smith, thank you for being with us. Bill Fivoldo, as always, thank you. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU.
Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.